Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm here to help you make the most of your mineral rights and royalties. And my co-host, Justin Williams, is here with me as well. Justin, how's it going today? Sleepless nights. We were talking before we hit record that as you and I both get older, I know that I definitely need sleep. You were talking about lack of sleep here, huh?
Yeah, absolutely. 5 years ago, I could drive through the middle of the night, get here, get up at my normal time the next day and feel great. And we were talking about how, well, that's just not the case. As you get older, it's kind of like a science experiment. You need the right conditions, the right temperature just to get a good night's sleep.
That is so true. And I'm a big data geek being an engineer. I have what's called an Aura ring, and it's like a sleep tracker, and it tells you how much deep sleep you got or how much REM sleep or whatever. And I definitely notice, I can tell when I've eaten too close to bedtime, that definitely hurts my sleep quality. And then even just having like one alcoholic drink, having a beer or a glass of wine with dinner, and it's amazing how that affects your sleep quality too. And I'm really bummed about that because I definitely enjoy a nice glass of wine with a steak or something like that. So I still have it, even though I know it's going to mess my sleep up. But I think as you get older, you just got to plan ahead and say, okay, what do I have going on tomorrow? Is it something that I need to actually wake up early? Maybe I should hold off on the alcohol or whatever. But yeah, it definitely is a bummer.
You nailed it, Matt. And, to your data point, there's some things that's just worth not knowing. And I think sometimes those are some things. And as I get older, I am learning it, whether I like it or not.
Yeah, ignorance is bliss in that case. But when it comes to minerals and royalties, ignorance is not bliss. And so we're going to talk about a topic today that often leaves people grappling with uncertainty if you are ignorant about, what to do. And that uncertainty can lead to issues. And what we're going to talk about specifically is how to navigate inheritance issues with mineral rights and royalties. Whether you're an heir that is finding yourself in possession of these valuable mineral rights and royalties, or someone who wants to ensure a smooth transition for future generations, that's what we're going to unpack today and go over some practical strategies and advice that you can use to help avoid some of the most common challenges that arise when you're dealing with inherited mineral rights and royalties. Justin, I know that you've gone through this process. Do you want to talk about some of those common challenges that you faced or that you've heard others face?
Absolutely. It's something that doesn't get talked about as much as it should is transferring ownership. And that's one of those that, we all kind of know as mineral right owners, that's something that needs to be done, but it's very easy for that to be forgotten. There's also dormant mineral statutes. So in some states, ensuring that those minerals have been titled over is vital to make sure that they don't revert back to the surface right ownership. And then how to manage multiple heirs, how to avoid disputes between your heirs, how to convey those assets in the easiest and simplest way for your heirs and for you, and then how to preserve and maximize the value of inherited assets. Something we talk about at Mineral Rights, Matt, is how many times it's split between heirs throughout the generations. And there are some tactics that you can use to minimize that, to keep everybody working together and to keep your interest as large as you can, which makes it beneficial for everybody.
Yeah, that's a huge point. And we'll talk about that and why that becomes such a big deal as time goes on. And we've talked about inheritance in the past, and we're going to refer back to a couple different episodes. And we'll have a resource guide that you can download if you've inherited minerals or you're looking to pass on your interest to your heirs. We'll kind of put this all together in a nice, easy cheat sheet that you can use to link to all this so that you make sure that you're doing all the right things. And, specifically in episode 39, one of the first episodes where we talked about this, we talk about some of the basic considerations, whether to keep or whether to sell. And we talk about the ways that you can convey them, like Justin mentioned. And then we talked about some of the definitions, the different things like probate versus ancillary probate versus determination of heirship and all those kind of legal, technical processes that you have to go through sometimes. And so we'll talk about that in more detail. What we're going to talk about today instead is to focus on some of the more complex issues that are faced by people that inherit minerals, or if you're a mineral owner looking to pass these on, how to do it in the best way possible to avoid some of those common challenges that Justin mentioned, and hopefully do this in a way that you achieve the goals that you're looking for if you're passing these on, or if you're inheriting these assets, you understand how to properly manage them and how to maximize the value, because this is a unique opportunity we have in the US here, Justin, the private ownership of mineral rights and royalties.
You nailed it. And on that note, let's start with unpacking the basics on understanding inherited mineral rights. As Matt mentioned, the United States is one of the few unique countries that allow private ownership of the mineral rights. It's one of the factors that enabled the shale revolution, and now why the U.S. is one of the top oil producers in the world. In our episode 152, we featured a video from Steve Forbes talking about this. This example he gives is in South Texas, a prolific oil and gas play in the Eagle Ford on the U.S. side of the border, whereas in Mexico, this is not the case, even though the geology is similar in both areas. Because Mexico and most other countries have a top-down approach, they are the ones that own the mineral rights and not the citizens within those countries. In most states with mineral rights, ownership is perpetual, except for states that have those dormant mineral statutes like we talked about. In episode 66, we really go into detail on what dormant mineral rights are, how do they expire, and those mineral rights, Matt, are a form of real property passed down through a deed. So very similar to conveying a house or something else, those are considered real property.
Yeah, that is a key thing. If you've just found out that you're going to be inheriting mineral rights, like Justin said, it's real property. It's something that usually ownership is perpetual. Again, there's some exceptions to that in states that have those dormant mineral statutes. If the mineral rights are non-producing, you may have to do certain things to assert your ownership and to maintain that ownership. But in general, the amazing aspect of that, and the reason that we are having this conversation, that these types of assets can actually be passed down hundreds of years after your ancestors originally were granted the rights to maybe the surface and the minerals under a tract, whether they used it for farming or ranching or whatever the case, and they earned that by providing value in some form or fashion. And now your family's benefiting from that ownership, and you pass that ownership down through the generations. And that's why mineral rights are so unique in the United States, because you can have that transfer of ownership between different generations, and it can stay within a family over time. And so that's an amazing aspect, to this as well.
You nailed it, Matt. Yeah, it's often a link to the history of your family and maybe a link to where your ancestors worked or lived. And it's a very interesting thing to research. Not only that, there's value to it. Mineral rights can be leased, and you can receive lease bonuses, and that can be done several times over a lifetime. There is value in those. And mineral rights and royalties. So when you're inheriting mineral rights, there are some legal considerations involved. How are you going to transfer those? What is involved in transferring them? And there's a few different options. So individual ownership is probably one that we see more often, and that has to go through probate. So when your ancestor passes away, there's a probate process that allows the transfer of that title. And in episode 85, we talk about probate and marketable title with attorney Richard Winblad. And we kind of go through what probate means, how that process works, how marketable title plays into that. And then there are other options. So there are trusts, there are family LLCs, and there's other legal considerations into how you're actually going to pass those minerals on to the next generation. And each of them have some very unique aspects, Matt. Some people will say that some are better than others. It really depends on your individual situation and a conversation with your attorney and CPA to know what works for you.
Yeah, and this is a very common situation, and I get calls or emails on this topic, saying, "Hey, my mother-in-law inherited mineral rights in Texas and Oklahoma. We're interested in selling, but we can't seem to find title to the property. Was it ever transferred to the mother-in-law? Who knows? Probably not. Maybe they are receiving royalties, or maybe they're not." And then this just puts the heir to these interests in a precarious situation, because they're not quite sure exactly what they own. They don't have clear title, so there's an expense that they're burdened with to clear up that title. They need to hire an attorney, like we talked about, in the state where those mineral interests are located, in order to reopen probate if maybe the minerals weren't included in the rest of the estate. Sometimes you have to go through the process of getting title over so that you can then do whatever you're going to do with them, whether that's hold on to them and receive royalties. Most operators will put the interest in what's called suspense. In other words, they'll withhold royalty payments until they know who they should be paying. And the only way to do that is to go through the courts to have them determine who is the rightful heir to those interests. And then once that has been adjudicated and there's some proof of that through the deed, transferring ownership, then they'll go ahead and then start paying you. But that's a headache that you have to go through. There's an expense, several $1,000s, usually in each state where those are located. So that's a burden you're putting on your heirs if you don't act proactively in managing these types of assets and how you're going to pass them down. And that can all be avoided. So I think that is certainly something to think about. And we talk about, some of the different ways to do this. And this shouldn't be construed as legal advice. Everybody's situation is different. You need to get with an attorney that is qualified in your jurisdiction and make sure that you get advice specific to your situation. But in general, some of the ways that you can avoid having to go through probate, and if you have a trust and you properly fund that trust, in other words, the ownership is conveyed to the trust, then you could potentially avoid probate. And then also family LLC or some other entity like that. You have multiple owners of those interests within the LLC, but the interests are deeded over to the LLC, and you can change the ownership without having to record a deed. And so that's another mechanism that you can use to streamline this process and then help your heirs avoid probate, because that is something that either you want to have it taken care of and have that inventory of assets clearly outlined in your will, so that when all of the other things go through probate, that your mineral interest also go through probate, and then that's taken care of. But just know that there's an expense that you're going to be potentially burdening your heirs with.
Absolutely, Matt. And, some of the common challenges we see when people are inheriting mineral rights and royalties, I think at the very top of that list, it's so common that the first time that someone is aware that the family even owned mineral rights is when they've inherited them. And this can be overwhelming. It can be confusing. It's a private property that you never knew your ancestors held. And then now you've inherited it and you don't know what to do with it. Another thing that I think people struggle with is it's such a unique thing. Not only do they not know what to do with it, but they don't know where to go for help. If they pick up the phone and call the estate attorney who worked with their ancestor, that might not be the right person for oil and gas. They may really need that specialized oil and gas attorney, or at least somebody who has familiarity. Along with that lack of knowledge, the timing can often be unsettling. So when unsolicited offers to purchase the interest comes in because potential buyers saw that a deed was recorded, it's at a time where the heirs may be looking to sell property. It may be a time where the owner doesn't really know a whole lot about mineral rights, and it puts them in a situation where they can make decisions that could leave money on the table, or maybe they're making a decision based on an understanding that's not complete yet. It also can really be unsettling that you're getting these offers to purchase it. You don't know why, you don't know where they're coming from. And then along with that is working with the operators. If you have a property that's in pay status, going back to the operator and transferring the ownership over the operator from whoever it was previously to your name or names, depending on the situation, can really be tricky. And then on top of that is title issues, Matt. So it's not uncommon in the mineral rights world to have title issues. And that's something that a lot of times people work with the operator, may have to get an attorney involved to really work with them to make sure that the operator is comfortable with the way that the title was conveyed and who owns that property, and ensuring that there's no disputes, especially if there was multiple heirs. Another thing that ends up happening, and Matt, I am a case of this, is not having a complete inventory of the assets. It leaves heirs wondering if there are other interests out there. What were the interests that were part of probate? And it can be reinforced when they get called out of the blue by landman offering to lease interest that they didn't even know they owned, or again, getting buy offers for properties that they had absolutely zero idea that they owned. And Matt, my example is very much a case of this. My ancestor was sick at the end of his life, so he had Alzheimer's, and he was unable to really put together a complete inventory of his estate. And through that process, it created some major headaches for understanding what else could be out there, what was or wasn't conveyed into the trust, what parts of the trust were used, and just a lot of question marks. And this is something that you can really do your due diligence to try to minimize, but you hope for the best and plan for the worst. It can happen, and it does happen.
No, that's an excellent point. And we've talked about this earlier this year. We had an episode, it was episode 191, making it easier for the next generation. And that's definitely one of the things that can be done to help your heirs is to provide that inventory. Here's all the stuff that we own. And the next step beyond that is to educate those heirs, have the conversation, while you're still alive to say, hey, did you know that our family was blessed with the ownership of mineral rights? And here's where they are. And here's what I've learned about this asset. And here's some things to think about if you're interested in, man, this can be a amazing legacy for our family. Here's some resources. Maybe you invite them along to a meeting or a convention with the National Association of Royalty Owners, or NARO, which Justin and I are both on the board of our Rocky Mountain chapter. And one of the things that we do within the organization is really focus on educating mineral owners. And that's one of the primary missions of the organization. It's to go through and teach. And we have educational sessions in these conventions where we have professionals come in, talk about issues that mineral owners face, how to deal with them. We have webinars and things like that. And so if you think about identifying too a potential heir that is interested in taking that role on for the family, you want to help give them the resources to ensure that they're going to be successful. And that might be inviting them along with you to a convention, whether it's a state or national convention of NARO. There's educational resources, making them aware of this podcast. Hey, this is a resource that I've used to help learn about this asset. Here's some of my favorite episodes, or here's the things that you should think about as you're inheriting this. And that we're hoping that this episode can be a resource that you can use to share with your heirs and on the things that they need to be doing and the things they need to learn about to make the decision whether it's something they want to take on behalf of the family. Because that is a conversation that you should think about having with the heirs to this property, so you can make sure that it's going to be left in capable hands if you intend for this to be kept within the family over multiple generations after you're gone. Those are some things that you would need to work with an attorney to figure out how to structure that so that that happens. Because if you don't, what's going to happen is the scenario that we mentioned earlier where your heirs are going to be surprised that they inherited this. They get unsolicited offers to sell that seem amazing, not knowing the full picture of the value of these types of assets, which usually the first offer you get to buy could be leaving money on the table. And so there's different things you can do to educate the next generation of mineral owners. And you want them to make the most of that asset that you've entrusted them with. And so I think you'd want to share different resources. Those things I mentioned before. I have a mineral management basics online course that's coming up for those that want to take on the role of managing these types of assets. The other thing you can do, one of the structural ways of managing this, is if you do identify an heir that is interested in managing these types of assets on behalf of the family, maybe they could be the trustee of the trust. They could manage the mineral and royalty interests on behalf of the other heirs. And so they can take on that role. And I've worked with several clients that have done that and done so successfully. And so if you have multiple grandkids you're passing this on to, or multiple kids, not all of them may be equipped or maybe willing to learn about this and take an active role in managing it, but maybe one of them is, and they could help their siblings out by taking on that role on behalf of the family. So that's something to think about. I think that's an important conversation that needs to be had as well.
You nailed it, Pat. And also not uncommon, as you mentioned. That's something that I know I have seen a lot as one person handling it for the family. And it works out well. Avoiding inheritance disputes. So this is something that I think even with the best planning, sometimes you can make mistakes and it causes disputes. But there's potential sources of conflict among heirs whenever you are splitting this property up. And it can cause conflict because people feel like they should be getting more, or they feel like they got less than the other heir. And it's a situation where even when there was some good intent that goes into it, there's a lot of legal complexity that comes into place when minerals pass through a state. So it can cause a lot of conflict, and it gets highly technical when you're conveying minerals. Some states have certain provisions that are very specific on how it must pass through marriage estates, so on and so forth. And Matt, you have an example here of a client of yours that has kind of experienced this almost exact thing, and this seems to be very common.
Yeah, this is an interesting one. And, I'll try to explain this in a way to illustrate how these interests were passed down. But basically, they had a great grandfather that was in the oil business and had a bunch of overriding royalty interests. These are now very valuable. And so the way that these were handled at the time, the great grandfather passed those interests down to his kids. So that was my client's grandfather and great aunt. The great aunt died and gave all of her share of the interest to her favorite nephew, which was my client's father. So what happened then at that point was that the client's grandparents and then the client's father each had an equal share. The interest on the other side passed on to my client's grandmother, who gave the interest to her two sons, which was again my client's father and their uncle. And the client's father was at that point inadvertently left with an undivided three quarters interest, and his brother, my client's uncle, was left with an undivided one quarter interest. So inadvertently ended up getting a little bit more than the brother. Well, I think to make the brother, he was in good terms with his brother. He didn't feel that it was fair that he got more. So he transferred the undivided one quarter interest that he inherited from his mother to his brother so that they would both be left with an undivided one half interest. So, kind of a convoluted way, if you can kind of picture that in your mind. Ultimately, I guess the big thing to take away here is if one sibling gets more because they inherited a portion from a relative, like an aunt or an uncle or something like that, that the other, sibling didn't get, it can leave the sibling that got less feeling left out, feeling like there's some bad blood now between their sibling that got more. Maybe they were getting along fine before that, but this is causing some discontent within the family. And that, from a inheritance standpoint, I'm sure that was not the goal of their parents or their aunt or uncle or whoever ended up giving them the additional share. It just ended up that way. And a lot of that happens when you don't have a will that clearly spells out who should get what. And so the laws of intestate succession have to be followed in order to divvy up your assets when you go through, the courts and they say, okay, here's who gets what based on the law. Since there isn't a will, we have to figure out who's going to own this stuff now. And so one way to avoid that is to, of course, have a will that spells out clearly where your assets will go. And so that ultimately it goes to who you want them to go to in the percentage that, is equitable if that's what your goal is. And the other thing is that this could have been avoided. Maybe if it had gone through a trust and then maybe the situation is that it's then clearly spelled out in the trust who gets what. And then who becomes the trustee is maybe the person that just wants to take on that additional role. And it's additional work. So it's not like they're perhaps, getting more of the share of the family's interest. Maybe they're getting paid a little bit to help offset the time commitment because it's not, something that doesn't take time for sure. So that's something to think about is if you want to avoid these types of inheritance disputes is thinking ahead multiple steps. I know it's easy to think about, okay, I'm going to pass these on to my kids, but what are the considerations? What are the ways that your kids might be getting interest from your brothers or sisters? Maybe they don't have kids of their own and they're going to pass it on to one or more of your kids. And you want to make sure ultimately that both your kids get equal amount. Maybe that's a situation where you need to have a conversation with your brother or sister, asking what their plans are with their share of that undivided interest that they inherited and what are they going to do with those. And maybe there's an opportunity there where you can recombine those assets together to avoid some of the issues that we talked about as these assets get more fractionalized over time as they're handed down to different kids and grandkids and things like that. It becomes so small that the value just diminishes to where you're really impacting that and you don't want that to happen. So maybe there's proactive conversation you could have with your cousins or brothers and sisters and say, hey, how do we keep this in the family? How do we, keep the piece of the pie as big as possible, but then split up the proceeds from these assets equitably across all of our kids or heirs or whatever. So that's a conversation that can be had as well, which is sometimes not really thought about.
You nailed it, Matt. And I think having that conversation is really important. It's very much human nature to create that will, lock it away, and then to never really talk about it or go through it. And I think it's important that all of your heirs understand what they're getting, what percentage that they're getting, so that everybody's on the same page. Looping back to the example that Matt was given, situations like this where one person ends up with a larger interest than the other person can really put the whole interest in a state of unknown with the operator. If you have this one person going to the operator saying, no, this is incorrect, you're paying him too much, this is mine, it creates a cloud for the operator and it makes them worry that they're paying the wrong person. And that could really lock it up and force those heirs to have to go through a stipulation of interest or some kind of other document that defines to the operator who owns it. And that's just not a good situation to be in. And having that conversation, making sure that everyone understands the intent of your estate, how it's going to be handled, what percentages are splitting, can really help to minimize that upfront.
Yeah, those are all really good points. I think the next thing to think about as well is what others have done. So I think these are some examples. I gave the example of the client that went through that process, but let's talk about more practical, actionable tips at this point. If you're in the position now of inheriting minerals or you're going to be passing these on, let's talk, Justin, about some of the strategies that people can use to navigate some of these situations that we've talked about. And then lessons learned. I think, you've gone through this process and you've shared a lot of valuable lessons that you've learned on that. And then I know we had an interesting conversation with Barb Rankin, who's a listener in episode 120, and she talked about her experience going through inheriting these types of interest and what she learned. So, Justin, do you want to talk first about your experience when you found out that your mom had originally inherited mineral and royalty interests and that whole process? Because you guys were kind of caught off guard by that, right?
Absolutely. We definitely were. And most of the things that we've talked about, I think we ran into throughout the situation. And it was a case where my mom had inherited a portion from her great uncle. And it was something where other heirs had always said that, no, this wasn't correct. You weren't supposed to be an heir. And when it came down to really looking at the documents, what we found was that family lore and what the will and trust said were not the same. And so it was really a situation of working with attorneys to figure out exactly what this document says, how it says it. And then from there, trying to figure out with each interest what ownership percent was supposed to be passed. It was a case where there was a marriage share that passed through the great uncle's wife's estate, and that kind of split off into different percentages. And so it was really convoluted and complicated to get our heads wrapped around. Thankfully, we had some really great attorneys that were there to help us. And then once we understood what it is we actually owned, there were chain of title issues because those other heirs through family lore were told that my mom was not a beneficiary of the estate. Almost all of the properties were completely locked up for payment for both them and my mom because there was title disputes. And that was something where we had to go back and get a remedy for those title disputes, have documents issued, work with the other heirs to sign documents. For heirs that didn't want to sign documents, we had to reach out to trustees for the trust. It just was a really, really long story. And we took it one step at a time and were able to get it corrected and understand it. But again, if there would have been clear communication up front, if this would have been something that was communicated to my mom, if this was documents that my mom had access to, this really could have helped simplify this process. And I think there's a lot of value in having other professionals by your side that can really help you to understand this, especially if this is something that is news to you. Assuming that you understand it completely is just probably not the case. And step one is really taking a step back and working with an expert to say, okay, is my understanding correct? And then how do we proceed forward?
I think those are all really good points. When you think about those conversations, we make it sound really easy. And I recognize too that this is a difficult conversation to have, mortality. You're talking about, not being around and, maybe it's not the right time to have that conversation with your heirs, but at some point it needs to be done and you need to have that hard conversation saying, hey, I'm not going to be around forever. I want to make you aware we have in our family mineral interests and I'm planning on passing these down to you and your brother or whoever is going to get it. And, I want to make sure that you know that. And I want to tell you where to find this information. I mean, if you're interested, give you some resources where you can learn more about this because it's an amazing opportunity. Or if you're not interested, that's okay too. I just want to make sure you're aware of where to go for help so that you can make the most of this asset that I'm going to be passing on to you. And I know it's a difficult conversation and we make it sound easy. I know the reason that it doesn't happen is just because it is a difficult conversation. But you can also, it's difficult in the moment, but it's going to be a lot more difficult for your heirs if you don't have that conversation, because then they're going to be potentially taken advantage of or just trying to figure this out. They have busy lives trying to, raise their kids or do whatever. And now they're having this stressful situation they're having to deal with, even though at the end of the day, it's a blessing. In the moment, it may not seem like it if they're really stressing about what they need to do and they don't know where to go. So just some things to think about. Another thing to highlight in the conversation we had with Barb, again, that's episode 120, was that, to your point, is importance of finding the right attorney for mineral rights issues. We talk about this a lot, and trying to find somebody that isn't conflicted with working for oil and gas companies can be hard. But once you identify somebody that can help you, they can be an amazing resource to help guide you through this process that is somewhat daunting at first glance. And making sure that you're not wasting time with another attorney that doesn't understand oil and gas and the potential value of these assets, or how to manage them. And so there's a unique niche in the legal space, I think, that where you have like an estate attorney that really understands mineral rights and royalties. And oftentimes you have to go hire somebody out of state. If you're out of the state where those interests are located, you're going to have to hire an attorney that's licensed in that state to help you transfer ownership and all that kind of stuff. So it's important to have a conversation with that attorney and, tell me your experience with managing mineral rights and royalties and conveying these assets. What are your other clients? Have you dealt with this issue? Can you recommend anybody in that state? If they're not licensed in that state, they can help put you in touch with somebody, or you might have to do some research on your own. And we have resources on our website, as well as there's other things out there like the Mineral Rights Forum, where some of those folks have been helping other mineral royalty owners out with their questions. So those are places I think to go and to get help. But one of the things you need to do, I think, at the end of the day, is if you're going to take this on, you need to take an active role, at least at some point at the beginning, to understand what you have, to maybe do the stuff that Justin said in terms of getting things transferred over to your name, maybe doing a title search, things like that. But then once you get everything situated, then it becomes a more passive situation where it's the mailbox money you hear about. Then you can sort of take a little bit of a less active role. You still have to keep track of your royalty payments, make sure you're getting paid correctly and things like that. But just know that it's not going to be a full-time job forever. It may be a short push where there's going to be a lot of work. And I think that was one of the things that Barb had mentioned, was that you'll need to sort of advocate for your mineral interests as well. And, both at the state and national level, I think like we talked about, that was one of the things that she found value in, joining NARO and learning about that advocacy work to make sure that our interests are protected and our family's interests are protected over time. And we get to continue to enjoy that right of private mineral ownership. And I think just like you said in your episode, and then like Barb said, Justin, is the number one thing to is really learn about what you own and to get a complete list of what you own, and to make sure that the title is correct, and that you have the estate documents in place for you. Maybe you weren't left with a clean situation and had to kind of figure your way through this. You can make it easier for your heirs by making sure your house is in order, like we've been talking about. And I think that is something that is important to do, and to have, again, a good attorney and a good landman in the state where your interests are located so that you can get help with those things. One last thing that Barb mentioned, I think, which is cool, and I think you mentioned this as well, is that it really provides such a unique opportunity to go back through the timeline of your family history and to reconnect with family through mineral rights. So Barb mentioned a quote here I want to read that I think was really cool. She said, it's the other thing. It's been such a nice bonding for my cousins and for me because we saw each other a lot growing up every summer out on the farm. But then, as happens in life, you live in different states, you're busy with work, with life, and you become separated. And so this has been a wonderful way to bring us back together and have really enjoyed every moment of that. So I think that's another kind of side benefit of all of this. It kind of helps provide a way for you to reconnect with family that maybe you haven't talked about for a while. Maybe talk about some of the times you've enjoyed growing up with your grandfather and how what you all used to do together and how it's such a blessing that he left you these assets that, you're now able to go and reconnect on that common area that helps you relive that. So I think that's kind of a nice side benefit that maybe isn't talked about a lot, but there's that kind of emotional attachment or that personal attachment to the family and to history.
You nailed it, Matt. And, I think learning this process is most people find it interesting once they get into it. And though it seems like a lot of information, over time, it starts to make sense and you learn more as you grow. And it can be a wonderful way to reconnect with that family, but it's also a wonderful thing to learn new information about. And in my case, Matt, I've shown you, I found books that my ancestor were in through the process of researching mineral rights. And to just get that little glimpse into a life that I never got to meet is a very, very interesting thing. And not to mention all of the history involved in oil and gas, period. There's reasons why we came to the laws that we have today. And I find it fascinating to learn about why that happened and how we got here and why we do things the way that we do.
Yeah, that's exactly right. I think that's a really interesting aspect with minerals and royalties. So, Justin, let's wrap this up and talk about some of the resources that people can go to. I think that this is something where you're not going to really know what you need to know until you're dealing with a situation. And so having a resource you can go to, say, okay, I need to learn about probate and marketable title. Where do I go to find that information? Or I need to find out about trust versus LLCs. We covered a lot of this information and we'll, like I said, provide a link in the show notes where you can download a resource guide that goes over this information to provide some additional resources when you need it. Because this is a lot to take in if you're just learning about this or if you're going through the process of planning ahead and thinking about how you're going to hand these assets off to the next generation. There's some things to think about, and so we'll provide that link in the show notes to that. Now, one of the things I think that I want to recap, because I think it's an important aspect, is that knowing what you own is really the key consideration with both owning and managing these types of interests as well as the inheritance of these types of interests. And I think that to the extent that you can leave good documentation for your heirs, that they know where to find that information, that it's part of your estate documents and your estate attorney and whoever the executor of your estate is will find this stuff and rolls. And then all of a sudden you have all of the background information, all the history, all the stuff that we talk about that most people struggle with and trying to understand what it is they own and trying to find copies of deeds or oil and gas leases or other correspondence that could help provide some insight into the history of this asset so that you can pick up where they left off. I don't have to start from scratch and learn about this from the beginning. So that is something that we talk about, as far as knowing what you own, where it's located, what type of oil and gas activities going on, list of wells that you're receiving royalties on, copies of check stubs or division orders in that documentation you're going to pass on to your heirs. And then, being able to help, providing all of that in one spot, I think is important. Now, we talked, Justin, earlier about the issue with passing these types of assets down over time. And if you just do it with individual ownership, in other words, you just transfer it over to that person's name, you end up splitting up these interests, over time. Maybe your great grandfather owned 100%, your grandfather got 50% of that, and then your parents got 25% of that, and then you got 12.5% of that. Well, if you give another 6.25% to your kids, this, as you can tell over time, this is just going to get so small that it becomes almost more trouble than it's worth to manage these, or they're really not worth anything if you want to go to sell, just because they've gotten so small and it's more effort for the potential buyer to go through and figure out transfer everything over. It's the same amount of effort they're going to have to go through, whether it's 100 net mineral acres or it's one net mineral acre. And if it's a really small interest, they're not going to want to go through the time and expense to run title. And if you just have a check stub or division order, they may take that as proof that you are the owner, and they're going to discount the price they're willing to offer you because there's a little bit of uncertainty as to whether or not you're the rightful heir, or if they're going to get rug pulled and find out that you never even owned it. So if you want to maximize the value of these assets, maintaining the integrity, in other words, keeping them whole, and then splitting ownership through different members of, an LLC or through a trust, you can have people benefit from the ownership of this in totality and have their interest within that. Now, there's some other considerations that go into that. Obviously, with undivided interest, if you own title in your name, you can do whatever you want with it. If it's held in a trust or an LLC, you kind of have to go with the predominant sentiment as to what the family wants to do with those assets. But it does help maintain that value so that you aren't dealt with a situation of having, instead of 100 net acres within the family, it's a tenth of a net acre, and it's not even worth the time and effort to go through probate because you're never going to get the money out of it when you get paid royalties. So something to think about, especially over time. They're going to get subdivided and more fractionalized over time. That's going to make it less valuable. And so I think that's an important thing to think about.
You nailed it, Matt. And we hear that story all too often where folks are faced with inheritance, but again, it's such a small interest that the fee that the attorney wants, the money that the landman needs to do the research, it just doesn't make it worth it. And your point to keeping it together really can help to make sure that there's the money coming in that makes sense to do that research and to do the proactive management of those minerals, where when you have such a small interest, it's all the same amount of burden, but there could be a lot less win on the other side for the person.
Absolutely. So I think that's a good place to wrap up here. I think that as you're thinking about the key considerations with these types of assets, again, you want to make sure that you are proactive, I think, in how to transfer these mineral interests to your heirs over time and how that's going to go, thinking ahead about who's going to get what from different branches of the family tree, not just your branch, but maybe your brother or sister's branch, and how does that get distributed equitably to avoid disputes. How do you preserve and manage and maximize the value of these interests? Like we said, when maybe it's keeping it in a trust or an LLC, and providing the resources to your heirs so that they are educated and they can advocate for their own interests and they know what they're worth. I think that's, at the end of the day, the ultimate goal. Whether they're going to hold on to these and pass them down to their kids, or if it's something where they look to sell, you want them to be able to get the most for that asset. So maybe it's getting an appraisal or understanding exactly what that property's worth, so that they can negotiate a good sale. So that's, I think at the end of the day, some of the things to think about. There's a lot of people that are here to help, whether that, again, is an attorney, your CPA can help from a tax point of view. We didn't really talk about that too much, but there's some tax considerations. And again, those are all conversations that you can have in advance with your attorneys, with your CPA, just in planning this out to make it as easy as possible for your heirs. And if you're inheriting this and you're really wanting to know, where should I go to conduct further research on this? How do I learn more about how to manage this type of asset? Again, go to the show notes for this episode. We'll have a link to a resource guide you can download that'll have all this at your fingertips. And then again, there's a lot of free resources out there, whether it's through this podcast, through websites like the Mineral Rights Forum, where you can talk to other mineral owners that are going through the same type of thing, and through my online course that's coming up, Mineral Management Basics, where you can learn about how to find out what you own. Maybe you weren't left with a situation where you know everything and you need to do this research. I'll teach you how to go through the process of researching these types of assets and finding out where they're located and what kind of oil and gas potential there might be with that asset, so you can maximize the value of this amazing resource that we get to benefit from here in the United States.
You said it, Matt. And for all those going through this, patience is a virtue. take it one step at a time and let your understanding be building blocks. I know for me, in my experience, I learned one thing at a time, and each time I learned something else that built upon the thing that I had originally learned. And I think people can get so frustrated with not being able to very quickly take this all in, but don't let that be the case. It is a slow learning process, and you just get better and better at it.
That's right. Well, thanks again for listening, and we'll catch you in the next episode. Thanks again, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.